Guys, welcome back to the Docket Dodgers. Glad to have you back here again today. And Wade, we're going to switch it up a little bit. I feel like me and you, we have been focused very heavily on sports law. That I was saying, hey, maybe we should just become a sports law YouTube channel. But we're going to switch it up. We're going to go back to our roots. We're going to do some criminal defense today.
Yeah. Local to us, back to the Mickey Stein's case in Eastern Kentucky. Excited to see what happened today.
Yeah, I am too. They had a hearing today. They had several hearings on the docket. I've not watched it. I see our local media company here in Mingo, Pike County area streamed it on Facebook, and we were able to get a hold of the video. And so we'll watch that. I don't know what was brought up, but I know motions were filed before on the dismissal and the indictment because there was something wrong with the indictments. It said that there's something where the grand jury happened. I don't know. I didn't get to read that case in full. And then also, I think they talked about. I think they're trying to do some sort of mental defense. So
I think that was one of the big issues today, and also bail.
Oh, is bail covered today?
I think so. Well, when they broadcast it, they didn't have the audio, so people are like freaking out about that for a little bit there.
I seen that, and when I was downloading it to my computer so we can play it today, I about the 7-minute mark, I noticed that the audio came back. So we might fast forward to that point. I think they were arguing. The jury issue about the 7-minute mark, and we'll try to fill in the gaps what we don't hear. So let's pull it up here. Let's go here. And yeah, there's no audio. Scroll. I can hear it a little bit. What about you, Wade?
Yeah. It's poor. They said it was a court issue and not a them issue, but who knows?
Okay. We'll try to watch it a little bit here, and we'll try to see if we can fill in the gaps here. See if we can try
Recording in progress.
I think Jeremy Bartley and Carrie Bartley are their husband and wife team.
Did they do the airplane case? Or no, different guy.
That was the Epperson guy. The Epperson guy did the airplane case. I think they're talking about the mental evaluation being under seal. And the reason why they do that is because there's a lot of private confidential information in a mental evaluation. So I don't actually think those can be released to the public.
The defense wants to go for that mental break defense. Like I think they would want those in, but probably do you show that to the jury?
I don't think. I think you get your expert on the stand, and you try to get that defense in that way, and it may go for weight if a psychologist deems him to be competent. Then when you will be arguing to the jury that he probably has some sort of psychotic break at that time, and the jury would, if they'll put their expert on the stand, I'm sure their Commonwealth will put their expert on the stand, and they will argue that point. But I'm pretty sure. I mean, if Mickey Stein walks into my law office and he wants me to defend his case, we have it on video. I mean, what I'm telling Mickey Stein, I'm going to tell him, hey, you're going to go to jail. And it's just a matter of what you're going to be charged with and what you're going to be convicted on. Are you going to be convicted on first degree, second degree, or manslaughter? You're trying to really mitigate at that point. You're not really trying to get a not guilty plea. You're trying to get a mitigating verdict at that point.
Yeah. It happens so quickly. It's hard to say that it was premeditated.
Mm-hmm. I wonder if I don't have my chat up here, and I'm just wondering if there's some way we can chat. Oh, here's comments. Just now being able to see you. Yeah, Randa, we talked a little while before we went live. I had to reset up so that way I can get a good Wi-Fi connection. But let's go ahead. Let us know how the audio sounds, because it's really low on Mountaintop Media. It's for the first 7 minutes. You guys might not be able to hear it too well. Wade and I can hear okay because we have our headphones in. But I don't know how well the audio will be through your TV or through your phone. You there, Wade?
Yeah.
Okay. That's probably them.
Judge, you give us 10 days. I think we got it last week, so if you give us 10 days to respond to that motion.
What was it? Let me go back here before we come back. I don't know what I did there. Okay, good. I was afraid I was going to miss it. Barely hear it. Can you hear us good? Oh, you can hear us good? Yeah. Randa, whenever it gets to about the 7-minute mark, it will the audio will get better. I think I went too far there in the proceedings. Here we go. No audio right now.
Yeah, I can't hear them at all.
Judge, you give us 10 days. I think we got it last week, so if you give us 10 days to respond to that motion.
I wonder what motion to dismiss or talk about. I've not seen that.
Me either.
Okay, now they're going to argue the jury issue. Oh, there we go. They turned it up right there.
I think you're having some bleed through on your mic.
is what was going on. And I don't know, there's no reporting, but if we presume that's what's going on, unless there was some sort of, telepathic thing going on, there had to be statements made to the grand jury that said, hey, this is this case, this is what we know. And I think the Commonwealth was making a distinction that, well, if you don't come in and raise your right hand and swear, it's not testimony. Well, actually, the distinction is sworn testimony or unsworn testimony. And I'd submit to you the only way basing that on some sort of
there we go.
probable cause or evidentiary standard that you want the grand jury to consider, which is the only thing that makes sense. You have to tell them something. They didn't walk into the grand jury room.
They got two audio.
Just look at each other and the
Yeah,
grand jury
double
says, hey,
feed.
we'd like a more evidence speak. Now, I will say this. I do agree that the Commonwealth can, their legal advice to grand jury and the grand jury deliberations do not have to be
There we go.
transcribed.
I'm gonna say
Whatever was
something.
said to the grand jury.
This is much more pleasant.
I'm just going to say if the local media is going to do this, they're going to have to get this figured out because, like you said today, you have people like losing their crap because they couldn't hear this stuff. And
No,
I mean,
It's important.
if you think about our area, I mean, we've not had big cases in Eastern Kentucky, Southern West Virginia, and I mean, we had two back to back within a year of each other, and so I mean, we have we don't have a huge community in Eastern Kentucky and Southern West Virginia, but we have a pretty big community. Our citizens are worried about it, and this is going to be one of the most watched things in our area.
Yeah, and giving the contract to only one news agency, you would expect them to have the very best. But they blamed it on the court. They said it was a court issue and not a them issue.
I'm not even blaming the local media. I'm blaming everything. We got to figure it out because I know Court TV, they streamed this today too, and I think they're using the same pool, so it's not just a local media problem.
Oh yeah, it's going to be broadcast across the country.
Yep. So let's go back and listen.
Huge deal to ask for or form their basis for asking for the medical records judge. I think that should have been recorded so we would have that available. And I think 516 requires it. And the remedy is that conformity shall form a motion to dismiss. I can address the other area, Judge. And the second area, Judge, that may need an evidentiary hearing. It may not. I mean, I'm not sure. Well, I'll leave that to the Commonwealth as to the response to that. But in terms of the other portion.
You're talking about the statements made during the actual grand jury presentation?
Yes, Your Honor.
Okay.
As to the second portion of my motion, it's based upon Commonwealth v. Baker. And Mr. Cox actually handled Mr. Baker in that case. We all know it in the prosecutor's community is the aluminum bat case. Detective goes in, testifies, and says, basically there was an aluminum bat used. This woman used an aluminum bat. In reality, it was a wooden stick or something like that. And in that case, when the following conviction and an appeal based upon that testimony being misleading, the Supreme Court sent it back and said, look, if you give evidence to a grand jury, you can't mislead. And the bigger debate really seems to be after that, does it rise to prosecutorial misconduct, which should stamp it with prejudice, or is it not? And to me, that falls into the without you represent to the grand jury. And so when I look at the grand jury transcript, Judge, again, without getting into the KCPC report, one of the big things that bothered me was the grand jurors. First of all, they spent nearly half the time asking questions, and a large portion of those questions concerned the mental health of Mr. Stein. And the last question before the grand jury retires for deliberation was, so he was in a sane mind as far as the investigation has gone, and the answer is yes. That's Detective Stamper testifying. Now, first of all, probably not an appropriate thing for Mr. Stamper, Detective Stamper, to give an opinion on, but the rules of evidence, I get it. I mean, if there's an evidentiary issue, that's not what we're talking about. But here's the thing. If you're going to let a detective testify about sanity and render an opinion, that grand jury takes that to heart. He's seen all these facts. And I submit to you, without getting, I can't reference the report, but I'll say this. You're hard pressed to find much in the way of the investigation that
Wait, you there?
support
Yeah,
any
your video
adverse
came up.
opinion.
Okay.
And so this is what I believe. I believe that had they not been told by a prosecutorial stamped witness, someone from the government, that he was sane, they wouldn't indict this case. Or at least they might not have indicted on murder. And so what I think, Judge, is if, even if the court didn't find that this arises to a level where this case should be dismissed with prejudice, which is what was asked.
I don't. Did the video cut out too when I left?
No, the video kept playing. He's still talking about the prejudice of allowing the detective to talk about his sanity to the grand jury.
Yeah.
At the very least, I think this thing should be remanded back and sent back to the grand jury and let them hear the correct evidence. Would that statement be corrected, or at least take it out? I mean, I don't think they have to put on evidence that's exculpatory for us. And I don't think that it's a, they can let somebody opine to what an expert would say, even if it's a layperson. But if you do that, it can't be wrong. That's a pretty risky thing. And here, the investigation, it definitely didn't show he was in the same mind. And there's other additional issues, Judge, and that's one of the things we want to have the evidentiary hearing for, is to ask about all these statements and what the detective had in terms of the investigation. We want to put that on for the court to show why we believe that was missing, in addition to anything else, Judge.
And I do believe you agree would require bad faith for jeopardy to attach.
Yeah, I mean, Judge, I think that in the Baker case, they said it'd be reckless. I mean, because basically, and I do think it's at least reckless. But I think we need to hear more about what Detective Stamper knew. What he knows now doesn't matter. I get that. It's irrelevant, right? But what he knew the day he testified is very relevant. And I can think of one witness, an attorney, who specifically said, I think he's had a psychotic break. And so to say that your investigation so far is showing us in the same mind, yes, I think there's at least enough there, Judge, for let me put the witness up there and ask him.
Right.
And then, Your Honor, there are additional items that I think are also.
Okay, so let's break this down real quick, Wade, while we got a little stopping point where he tries to get another motion pulled up. The first motion was about the grand jury testimony was not recorded. Evidently, when they were going through the grand jury notes, they kind of found out that there were another proceeding, because a grand jury meeting on Sheriff Stein's, because it kind of referred the transcripts they had kind of referred back to the previous meeting. Is that what you understand?
Yeah, it's about this missing set of questions that they asked him, and they're saying it had to do with this mental health, I suppose.
Okay, and so it says that the grand jury testimony, when you look at the rule, says it shall be recorded. But if you look at what the case law says in Kentucky about grand jury proceedings, most of the time a court will not disturb a probable cause finding from a grand jury.
Yeah, it would be a lot to overturn it.
Yeah, and
they have an argument.
they do have a good argument, and talking about his mental health and all that. At that point, I don't. I think the judge said it had to be made in bad faith, and
But he was saying it can be so reckless that it's automatically bad faith.
okay, and so they said that jeopardy would attach at that point. Is that what the judge said? Jeopardy would attach.
I think the solution is to redo the grand jury.
Well, I think that's the solution too. But I heard, I swear, I heard the word jeopardy in that.
I don't know.
Let's see if we can go back just a tad. What are we on 1339? Let's go back to. Let's go there and see. I think it said that jeopardy would attach.
Specifically said, I think he's had a psychotic break. And so to say that your investigation so far is showing us the same mind, yes, I think there's at least enough there, Judge, for let me put the witness up there and ask him.
Right.
And then, Your Honor, there are additional items that I think are also of concern. There's a question.
You cited those in your hearing.
I cited those, Judge, and those are additional items. And if the court doesn't want me going about each instance, I'll just say that is the sort of thing that I think we need to know from Detective Stamper. If you knew these things, why did you answer this misleading way? And I think it's reckless at best. And I don't know. We need a hearing to find out, Judge, what I'm asking.
Here he is.
Unless the court wants to certainly take it under submission and dismiss without an evidentiary hearing, we would request that as well, Judge. But if not, we'd ask you to put on.
Sure.
Thanks, sir.
Ms. Dahl.
Thank you,
Well,
Your
I
Honor.
thought he said jeopardy. Maybe
The
I was
Commonwealth is of the position that we certainly acted in compliance with the rules of criminal procedure here, the rules specifically that were cited by defense counsel. And we would ask that if the court to dismiss the motion, to deny the motion to dismiss the indictment as it's wholly without merit.
She almost messed
Your
up.
Honor, here, counsel is correct in citing Rule 5.06 that we could have unilaterally issued a grand jury subpoena to obtain these mental health records.
Yep.
That is a power that the Commonwealth does have. However, in taking an extra step in the interest of transparency, as the grand jury is an independent investigative body, and to ensure that there was no argument that we were usurping our grand jury subpoena power, we appeared before the grand jury on October 17th of 2024 without a witness, specifically to ask for these mental health records from two different providers for the defendant. We appeared at that time. There was no witness. There was no testimony presented. Counsel, again, is correct that pursuant to Rule 5.16, had testimony been presented at that time, it should have been recorded and would have been required to be recorded.
Who appeared from the Commonwealth when that request was made?
Myself and Mr. Steele.
Okay.
Only the special prosecutors were present. No witnesses appeared on behalf of the Commonwealth. And so, Your Honor, the rule is clear. It requires testimony in order for there to be a requirement for recording. And there was no testimony presented this time. And I think that is apparent. The court now has a copy of the.
I just think that's kind of odd, Wade. I don't know if you've ever been involved in a grand jury, but I have. Usually, when you're on a grand jury, you're not there to issue subpoenas. You're there to, I mean, a grand jury has subpoena powers. A grand jury can subpoena you, but I mean, that's very odd. The norm is that the Commonwealth attorney subpoenas for the grand jury. You appear before the grand jury, not convening a grand jury for purposes of a subpoena. That's really doesn't happen. That's kind of like the backwards way of doing it. Now, say you and I were on a grand jury and we were listening to something and we decided that we want to hear from someone else. We as a grand jury can get together and subpoena somebody to come in and testify that we want to hear to testify from, but they just don't really get the grand jurors together in a room and say, hey guys, we're getting y'all together. We're not going to bring an officer in and let you determine probable cause for an indictment. We're just going to get you guys together to see if you guys will sign this subpoena. I mean, that's not how it works.
Yeah, that's a weird goal of them to convene, especially if they took, I think it was they took a break and came back, and this was a multi-day thing. I don't know.
Yeah, I just the Commonwealth asking the grand jury for before a subpoena is really odd to me when they have the subpoena power themselves.
Yeah, unless they are trying not to get it done.
actual recording of the grand jury proceeding for the testimony that was presented on November 21st, the only time that testimony was presented. And I believe a review of that testimony, some of which is referenced in the Commonwealth response that have been filed, will show, based upon the questions that were lost by the grand jurors, the only thing that was requested at that time were this grand jury subpoenas for those medical records. I think that's reflected in the context of the
Maybe not.
recording of the grand jury presentation.
And as an officer of the court, are you representing that was the only request made?
I'm sorry, Your Honor.
Are you, as an officer of the court, representing that was the only request made?
Yes,
There
Your Honor.
was no peripheral commentary or anything of that?
No,
matter?
Your Honor.
Just,
Just specifically request for those grand jury records, for the mental health records pertaining to the defendant, one from ARH and one for Leslie County Detention Center.
Mr. Steele,
Just a point of clarification, if I understand your question, as you can imagine, nobody in the grand jury room needed to be told what case this was or anything regarding the fact.
I would think that's a safe assumption.
When we went in and we said, we're the special prosecutors in this case, we're here just so we can get a grand jury subpoena for mental health purposes. They began asking questions of which we did not have an answer to.
Right.
We never answered any substantive questions other than that. That's something we're looking at. That's part of the investigation. Those matters will be presented to you later. There was never, of course, at this point in time, the preliminary hearing had already been had. The video was already out. Other videos had been released. There was nothing we added at all to, or any conversation regarding the case other than the investigation and why we needed the records.
All
That would have been it.
Go ahead, Mr.
And Your Honor, additionally, we asked the grand jury to memorialize what was being requested and as far as the grand jury subpoenas in writing, which was authored by one of the members of the grand jury and signed off on by the foreperson. The verbiage of that is reflected in the response as well, but specifically which records they were requesting and authorizing via grand jury subpoena. So those grand jury subpoenas were issued. The records were received. Those records were then promptly provided to counsel for the defendant on December 4th of 2024 in the very first discovery period. So in compliance with our discovery obligations, Your Honor. So the Commonwealth believes it's clear based upon the rules of criminal procedure that we acted in compliance with those rules. We have additional arguments as far as in the Jackson case. However, the Commonwealth does not feel it's necessary to delve into those at this time unless the court would like to hear them as they're reflected in the record.
I've read your motion, or I've read your response.
All right, thank you, Your Honor. So clearly, we do not believe any evidentiary hearing is required with respect to the argument that there was no recording made. That is apparent from the recording that the court already has. So no evidentiary hearing is required. As far as the second argument, turning to the actual content of what transpired and what did.
So let me ask a question there. If you're the defense attorney, I don't even know if this was possible because I've never had to dive into the area where I was questioning a grand jury. But I wonder if I'm the defense attorney, if I'm trying to subpoena grand jurors to ask if there were any testimony.
Maybe. I mean, when you have video evidence of your client walking into a courthouse and shooting the judge, you're probably going to have to get creative with your defense. And this seems very creative.
Yeah, it is very creative, but I think he's kind of got a point. I mean, the rule is clear. The rule says that all testimony shall be recorded or shall be recorded for transcripts purposes. And the reason for that is because you want to be able, as a defense attorney, or as a defendant, is to be able to challenge the probable cause. And that's kind of taking your ability away if you're not recording it.
Yeah, but the state's saying that never happened, that there was nothing to record. It was only just.
Also, trust the government, you're saying? Is that your point stance, is trust the government?
I mean, both sides is the government here. If you think about it, like, you're going to trust the sheriff? Are you going to trust the new special prosecutor? They're all connected.
Yeah, but I think that he does have a point there. I'm just really curious if there was any testimony because, like I told you before, I just think that's extremely odd to me.
Well, I think if there was testimony, I don't think they would be hiding that right now.
Right.
But because
they may be hiding it due to the fact that they didn't record it.
The fallout from that would be catastrophic.
Yeah.
Detective Stamper testified to and the questions that were asked during his testimony to the grand jury in November. Your Honor, I think defense counsel is conflating the role of a grand jury proceeding with the role of a criminal trial. It is very clear under the law that they are distinctly different proceedings. The grand jury is an investigative body. The Commonwealth has no obligation, as reflected in an abundance of case law, to come in, to present exculpatory evidence, and to attempt to mount a defense for the defendant. That is not the Commonwealth's obligation. Additionally, the rules of evidence, particularly Rule 1101, does not says that the rules of evidence do not apply to grand jury proceedings. So hearsay, opinion testimony, the right to remain silent, all of those things are not required to be adhered to at a grand jury proceeding. If they were, our grand jury proceedings would be the same length as a criminal trial. It's not tenable.
The reason a grand jury proceeding for 30 minutes is the same as a 3-week trial.
Exactly, Your Honor. And so I believe counsel's arguments are confusing the two, the purposes of the two. You know, hearsay is presented routinely at grand jury. Opinion testimony,
So he didn't make any deal about hearsay testimony, but I think it was opinion testimony. I think it was that she's kind of, undercutting what his argument was. His argument is that they believe that the officer was giving expert testimony, not opinion testimony to the grand jury.
Yeah, from his statements about if he was sane.
Yeah. What are they claiming that the officer said?
They asked him if he was competent or something along those lines, and he said he was sane, even though the officer interacted with people who implied that he wasn't. Like one of the witnesses there said that he had a break.
But so the officer said that he was sane, but I mean, is that an issue that a grand jury would even really take up, whether the defense of some sort of competency defense? I don't think so.
I don't think so either, because I would think competency, like self-defense, something like that, wouldn't come up there. That's like a jury question, right?
Right. Yeah. Wait for the trial jury. Yeah.
Yeah. Trial.
Yeah.
just Detective Stamper's testimony is presented routinely at grand jury. These are commonplace and they are permitted under the law.
You would agree, though, you can't be intentionally misleading.
Absolutely, Your Honor. Certainly. And Your Honor, the Commonwealth is of the position that an evidentiary hearing is not required. Everything that transpired when testimony was presented to the grand jury in November is captured on that grand jury recording. The Commonwealth cannot conceive of a reason to haul witnesses in to talk about what transpired because it's on that recording. And so we do not believe that an evidentiary hearing is recorded. Or is required, sorry, Your Honor. So, Your Honor, again, the court has that grand jury recording. We would ask that it be filed under seal as it was a grand jury proceeding. And we would ask the court to deny the defendant's motion to dismiss the indictment in its entirety without any necessity of an evidentiary hearing. And we would rely on our pleading submitted as well, Your Honor.
Thank you.
Your Honor, may I just briefly reply?
Briefly, yes.
Yeah, Judge, so I mean, I haven't compared anything. I said from the beginning, Judge, I understand, we're talking about the rules of evidence. The reason I cited to the issues where there were things that normally wouldn't come in is because there were instances throughout the grand jury when the witness was about to answer something the grand jury asked for and it was shut down. I was contrasting.
That's not unusual, Mr. Waller.
Oh, I get that, Judge, but my point is this, if you put that into context with what they let testify, then I think ultimately, Judge, if we put on that evidence, it'll show you that this grand jury was misled. I mean, the statement, to be honest with you,
so he's saying the omission
alone
is misleading.
He's saying the what now?
So he's saying like the omissions of what they asked, like they didn't ask this or didn't ask that, was misleading
Right.
on purpose.
Okay. But I still think it's a stretch. I mean, we talk about probable cause. Probable cause is a low bar. I mean, it's the same bar that they have to make a police officer to make an arrest as a grand jury needs to make an indictment. It's not that you have to have beyond a reasonable doubt or preponderance of the evidence or more than 51% that someone did something. It's just Was a crime committed, and was the defendant likely the one who committed it?
Well, the video would say yes.
Rendering an opinion on saying it is completely, in terms of, I get you don't have to be an expert judge, but if you say it, you can't mislead. And then, so I'm not asking the court to look at whether things should have been admissible or not. That, I'm not at all. My point is that the grand jury is an investigative body. And they don't get to dictate what they hear if the grand jury's asking for additional stuff. So in other words, if they ask a question and it's germane, and I'll talk about relevance, but if it's germane, it's their grand jury. It's not common grand jury. They're the investigative body. And so the reason I cited to the things that I thought shouldn't have came in is that it contrasts with other things that I think they asked and never got told because the questions were reformed. And that's why we're asking for the.
Well, thankfully, I've been part of about 20,000 cases being presented to a grand jury. I'm gonna listen to the recording, and I'll be happy to review that.
In your, if the Commonwealth.
Please, sure.
Thank you. I would like to make a distinction. The Baker case, we're talking about misleading to the extent of an aluminum bat
Understood.
versus a wooden stack
Sure.
stick. I don't think there's nothing even alleged in the pleadings, even if you take everything in the pleadings and that's been said today by defense as true, that would be tantamount or even close to that, Your Honor. You know, as far as the mental state of the defendant at the time of the offense, that wasn't even an issue at the juncture of grand jury. That hasn't been raised since by defense counsel. So, Your Honor, again, I don't believe that those arguments are well taken. We would ask that you deny their motion to dismiss in its entirety.
Understood. All right, and I will get an order out on that. One, if I need to hold an evidentiary hearing in it, if not, I'll rule on it appropriately and distribute that. After I've got the CDMS, Madam Clerk, place that under seal with the conclusion of the hearing. I am going to take a copy of it with me to review for purposes of reviewing the pleadings.
Yes, sure.
All right.
What do you think, Wade? What do you think the outcome is going to be?
I think he's going to say it's okay.
I think he's going to say it's okay too. I mean, you talk about grand jury. There is a Supreme Court case law in the state of Kentucky that says normally absence just total bad faith or reckless, like Jeremy Bartley was trying to argue there, that, you know, a finding of probable cause from a grand jury is not going to be a return of a true bill on a grand jury is not going to be messed with.
So that other case I'm not familiar with, but it seems the issue was a cop testified he attacked someone with an aluminum baseball bat versus a wooden stick. I don't see how that is necessarily more or less misleading than the mental state of someone doing a crime. Just when you think mens rea, like, or along those lines.
Well,
I can see a connection.
I think there's a big difference between a wooden stick and a little baseball bat, especially the type of charge that they're going with. If they're going to West Virginia and you're talking about malicious assault, I would think that a aluminum baseball bat would be more towards malicious assault than what a wooden stick would be.
I don't know. I think that's based on the injury, is it not?
Right.
Like you
It is
injured
yeah.
by a wooden stick just as much as a aluminum baseball bat, depending on the
Right.
injury.
All right.
Next, in regards to the bond hearing.
Yes, Your Honor.
Barbara.
Again, Carrie Bartley for Sean Stein's judge. And we filed our motion for the court to, and it's been back quite a ways now that we
Sure.
filed that, but we did ask the court to.
You think she
have
makes
a
them
whole
Which is
match?
not abnormal. I know we've had some procedural things.
What
You think she makes him match the tie with her outfit?
is it?
I think he has some pink on. I think
I thought it was
that's-
yellow.
Oh, I might have the wrong color.
Evaluation, so
Absolutely.
that
and
is
that's-
something that had to be done
We asked the
first.
court to hold off on setting it for an evidentiary hearing until after we received that report back. Judge, you know, I think.
Rennie
by-
said 100% that she makes him match him. Is his shirt pink?
I think his tie is, from what I can see.
Oh,
To criminal rule 440, I believe it is. We're entitled to an evidentiary hearing. I think it's going to be necessary for us to bring witnesses. We have some witnesses lined up. And I think it would be necessary for the court to hear that evidence and make its findings on whether there are several factors by statute that the court has to consider when determining whether bond is appropriate. And there's an added level here,
I'm
and
just
I
gonna say
anticipate.
something. Are they really arguing? Hang on, let me make this bigger here. I've really got to break this down. Are they really arguing in bond for someone walking into the courthouse and shooting the judge?
This is not just someone. This is the duly elected sheriff that they trusted to enforce the constitutional law of the county, a highly respected man, they would say.
Oh man, but when we think about factors for bond, we're thinking about dangerousness to the community. I don't know who else is more dangerous than someone who would walk into the courthouse and shoot a judge.
Well, I don't know if he has any other bodies during his time as a sheriff. This might be the only one.
I can only imagine. Here we go.
The Commonwealth will argue that Mr. Steins is not entitled to bond because of the way that this case is charged. Okay, so in that situation, Judge, they're gonna have to put on proof. It's actually their burden to show the court if that is in fact what they argue, and I don't know, I'm just anticipating, but it is their burden if they're trying to preclude him from bond at all to put on proof that guilt is evident or the proof is essentially, there's great evidence of the proof, right? And so I can anticipate what those arguments are going to be. I can anticipate all of that, Judge. But I think, given what we know, and again, without putting any of that on the record today, given what we know now, I think we'll have a heck of an argument on bond.
What would be your proposed bond, in light of the circumstances?
Absolutely, and given what his income is, given what he's able to post, and I think that's what the statute requires the court to look at, is what he could reasonably post. We would
Public
propose.
safety is a factor also.
Absolutely, there are
That's what
several
I think.
factors, Judge. I just think that in terms of what the amount would be, the court has to look at what he could reasonably post if he is in fact entitled to a bond. So our proposal, Judge, would be 50,000 cash or property with any non-financial conditions that the court would require of him. The court could set a host of non-financial conditions, Judge, as you well know. However, I think that given Mr. Stein's, and again, without waiving any of our, any of our ability to put on proof, I would ask the court to take a look at the fact that he is, the lowest possible risk level that one human can be in terms
I'm
of his
gonna stop it
pretrial
for a
service.
second. Pretrial risk assessment.
Yeah, they're talking about pre-trial risk assessment, and that's what I was getting ready to stop and talk about. They'll go out and they'll do those factors for bond, dangerousness to the community, and likelihood to reoffend. I'm pretty sure if they're saying this is a psychotic break, and then knowing Sheriff Steins and the person he was before, and they're trying to say this is an isolated incident, that probably the pretrial officer did say that he's probably not a risk to the community if he's out on bond, and they're probably saying that he's not a likely repeat offender. But I don't know how you're going to do that at the same time and say that he had a psychotic break and then expect the judge to let him out on bond, someone who's had known to have a psychotic break.
I think that's fact specific to what caused the psychotic break. I think the reason that they're going to say his psychotic break was because of the actions of the judge.
Mm-hmm.
I think that's their position on that.
With all candor to all parties, is something that, as a prosecutor, now as a judge, I don't have the utmost faith in.
I understand, Your Honor, but it is also something that the statutes require the court to take a look at. And there has to be some other evidence that the Commonwealth can put on, or some other evidence in front of the court that he would be a flight risk, that he would not return to court, that he would be a danger to himself and the community. And again, I think that's why it's important for us to be able to put on proof and to be able to put on some of the stuff that's in that case of PC report. I think that when we are able to show the court what's in there versus, all the other things, I just don't think there's anything to show that he's a flight risk. There's nothing to convince the court that he would be a danger to himself or others. And I understand why we're here, Judge, and I get that. But the courts have said consistently, and it's, I believe, the Abraham case, that you have to look at something other than the charge.
I
Has to be
understand,
something else, right? We can't just look at the charge defense.
but that can be factored in.
Absolutely. So, Judge, I think we're going to need that testimony and we're going to need that report. I would ask the court, again, without waiving anything, I would ask the court to consider setting a bond. The court, of course, can do that at any time. And that would be our requested bond, 50,000 cash or property. If the court wants to hear just a little bit about what we would put on, again, Mr. Stein is a member of this community for his entire life, born and raised here. He has a great deal of family support through all of this as the court can.
I don't think ties, community, and family support is going to matter in this determination.
You got to say it. He is the sheriff. Like, he was elected.
He has a wife and daughter that he can still go home to today. He was a member of law enforcement for basically his entire adult life, up until the point of his arrest. Is a respected member of law enforcement, a respected member of the community, and frankly, Judge, everything we've learned about him since then corroborates that. And I would have testimony to that effect. There's no evidence that he would be a flight risk. Nothing. He has no failure to appear on his record. He has no, property in the Bahamas that he can run off to. There's nothing. This is a man with a great respect for the law, and he's built his life around upholding the law and serving his community. Just there's nothing that I've seen that anyone's seen.
Hey guys, if you can hear, hit the like
frankly,
button.
when we put on our proof of
Subscribe.
we'll see there's nothing to say that he would not return to court. There's nothing to say that he would commit another offense. There's nothing to say that everything in this pretrial services report, respectfully to the court, is not correct. That he's a low 0-0 risk, Judge, because this is a man who, again, there's, with all due respect to the court and to everything that, for the reason why we're here, the court does have to look at something other than the offense charged. I know it's a good one.
I understand that, but this, you would have to admit, is a unique fact circumstance.
Absolutely.
This is not a whodunit. The actions are very evident. What the end result of that is, that's the purpose of the case as we're proceeding.
Yeah.
So, all right, I understand your argument. Still,
Your Honor, if I may respond, she went through a lot of the statutes. Unfortunately, she forgot the Kentucky Constitution, section 16 says that all people are entitled to bail unless is a capital offense. And the word she was looking for is when proof is evident, the presumption is great. There's just recently in 2024, a Kentucky Supreme Court case on this issue. It was out of Breckenridge County, if I'm not mistaken. The site on that is 2024 WL 298-2769. That is a case in which, much like we are sitting here today, the defendant was charged with capital offenses. The Commonwealth had made a statement on the record they were not seeking death in that case. That statement made at that point in time, the judge set a bond over the Commonwealth's objection. The Commonwealth then filed appeal on that issue. Supreme Court come back and did the exact analysis they're asking you to do. And basically, what he did in the community, what he did is irrelevant. The only thing that's relevant is, in fact, the charges themselves. And the Supreme Court said, if you are charged with a capital offense, you are not entitled to bail. And they overturned a circuit judge and sent it back to no bail. So there's a case already out there the Supreme Court issued last year. I gave you the citation for it. And the case number on that is, or the case name on that one, I don't think I gave you that, is Commonwealth versus Rodney Jones.
Even though you're not entitled to bail, doesn't mean you can't still be given a bail by the judge.
Yes.
And
I
think
don't
he's,
think the judge is going to give him a bail, but
I don't either, but this is prosecutor's kind of acting like he's precluded from bail the way he stated that. And I don't think he's precluded from bail. I just think he's not entitled to it, like it's not a right to have bail.
well, he's a prosecutor. He can't help it.
Judge, there's enough in the record already. You can take judicial notice. That's why the Commonwealth introduced the video here in the preliminary hearing. It's very clear what happens in the preliminary hearing. They were counseled record at the time, so there's not an issue. They did cross-examination of that. The record is very clear. The video is very clear. And Mr. Stein, in fact, took the life of Mr. Mullins. So that's all that's required. Even under the case law, the Constitution, he is not entitled to bail.
Your Honor, if I could
Sure.
briefly respond. I do have a piece of case law I can cite here, Judge. It's Burton v. Commonwealth. It is an older case. It's 212 Southwest Second, 2010, Judge. It does show that the court can take into consideration the mental state of the defendant when setting bond in a capital case. So if this case was basically where evidence introduced in a hearing on motion for bail showed defendant to not be guilty of murder, but only voluntary manslaughter, in the event that the jury did not find self-defense, the proof of guilt was not evident, nor the presumption, right? So I think the court can take that mens rea into consideration and that mental health evidence into consideration, which is again why we want to do the interview staff.
All right, thank you. In response, Steve.
Judge, I believe the case I cited speaks right to the issue.
All right.
Is he
All
on
right, as with
roll?
the other issue, like I said, here's what I'm gonna do.
I don't think so.
Mr. Steele, you said that you all would file a written response on the KCPC evaluation within 10 days. So,
On a motion to unseal?
yeah,
Yes, Your Honor.
why don't we do this? If anybody wishes to submit case law or supplement anything in regards to the pleadings on all three of these matters, if both sides will do it simultaneously within 10 days.
Within 10 days, Your Honor?
Within 10 days.
Yes, Your Honor.
Yes, sir.
And then that'll give us time. I'm gonna try and expedite rulings on this, and then we can start looking realistically more at setting a next hearing. And I think once we get these initial matters addressed, we can then start realistically looking at potential trial date
Yes, Your Honor.
for all parties. So
One thing, Judge,
Sure.
can we do 10 days from Monday, since today's kind of
Yeah,
shot? It's
10 days
weekend.
from- why don't we do this? 2 weeks from today.
Yes, Your Honor.
That work?
Yes, Your Honor.
Yes, sir.
Or you want the weekend and add one more Monday?
I'd
Mostly
rather,
your motions.
I'd rather, under promise and over deliver, Your Honor.
All right, why don't we do this? And both sides will have till Tuesday, September 2nd.
Yes, Your Honor.
That should get everybody plenty of time.
Thank you, sir.
All right, and then after I get those pleadings, I will notify the parties and we'll get a more realistic timeline on when we'll set the next hearing.
Yes,
All
Your Honor.
right, other than these three matters, I know we have one matter that we'll have to address ex parte that we'll talk about in just a minute. And for purposes of record, the Commonwealth, you've been given notice that they filed for an ex parte hearing in regards to funding.
Yes, Your Honor.
All right, and you're aware that the court will address that at the conclusion.
Absolutely, Judge. And just to make the parties aware of the talk of some chambers, we are looking for an expert on this issue. And
Sure.
and there's plenty channels we have to go through depending on what those come back as for an expert also. So we made council aware of that also.
All right, thank you, Mr. Steele. Anything else we need to address today before we adjourn before the ex parte hearing?
Nothing
No, Your
more to
Honor.
come.
All right, ladies and gentlemen, pursuant to the rules, what we're about ready to have an ex parte hearing in regards to one matter. I'm going to be in recess for about 5 minutes to give time for the courtroom to be clear. Obviously, defense counsel and the defendant will be able to remain for that part of the hearing.
Yes, Your Honor. Thank you, Your Honor. Would like to.
What's that?
Yes, Your Honor. We wanted to talk to him for just a minute.
Yeah, absolutely.
Take care.
All rise.
Thank you.
So I guess they're both looking at expert, I would say psychologists, mental health experts.
Yeah. There's something that made him have a break, they're saying. There's something that was on that phone. We speculated it all along that was something on that phone. Oh, there's Elizabeth Jones. She just texted me. Oh, she's live right now. No. Okay, yeah, she's live right now on her own. Elizabeth has asked her if she wanted to join us for a second, but she's live. But let me blow us up here, Wade. Yeah, I think this is what's going to come down to. What was on that phone? What did they see on that phone? What did the sheriff see on that phone that made him absolutely just lose it?
Had to be something.
And like we said before, that it's not. This is not. I'm hiring an attorney. If I'm the attorney taking the case, I'm not going in there to tell the jury that Sean Mickey Steins is not guilty. That's not what my goal would be. My goal is as a defense attorney is to mitigate it. There's no doubt in my mind that he's going to serve some serious jail time over this. It's just going to be how much Is he going to be afforded parole after so long, or what type of charge? Because right now they got him with aggravated murder, and what aggravated murder is, it's a commission to killing with like a deadly weapon. That's basically what that is.
Okay. No premeditation or anything like that in Kentucky.
Yeah, and that. Well, I think it.
The bringing the weapon is the premeditation.
Yeah, I think so. Let me look and see exactly. I'll tell you what we'll do, Wade. We'll pull up the indictment right now. Let me log on to my super secret courtnet here.
Okay. Well, I was just thinking, like, he's a cop, he has a gun, and like when they say, "Oh, you brought a gun," it's first degree murder, right? Well, he always has a gun. It's not it could be spontaneous, and that's normally the difference between.
Oh, so you said there's no meditation because he already had the gun with him.
Yeah, that was his job. He already had the gun.
Okay. Yeah, it's he's charged one as murder aggravated other than a peace officer domestic death of a child. And it's 50720 is the statute for that. Hang on, and I will bring up, well, hang on. This is the indictment. Yeah. I think they have his indictment sealed. I don't see it here. Have we seen the indictment before?
I don't think so. I think they've been keeping a lot of it under wraps.
Yeah. The indictment was filed, it says in the court case, on 11/21. But when you go to what's filed, there's no indictment here on file. So they must have the indictment sealed. But we do know what charge he is charged under. He's charged under KRS 507.020. And so what we'll do, I will pull that up and we'll bring it up for our viewers here. Let me go back to our StreamYard and we will share screen. Oh, wow. Oh, wow. Wade, you're so much better than this I am.
I just had practice. That's all.
Let's see if I can. I'll tell you what I'll do. I will.
You're the TikTok guy.
I'm the TikTok guy. Let's see here. What is in statute? I'll just save it and we'll bring it up and talk about it. Add PDFs. Your computer.
You're still sharing your first screen up there. You're not sharing it with the world, but you're sharing it with me.
I stopped it. Oh, here we go. Let's add this to the stage here. Let's see here. Remove that
from the stage and then add the document.
Ah, look at that. Any way I can zoom in on it, or is that as good as we get?
It's as good as you get. I zoom in it on like the side and just read it.
It's good to get. All right.
But I can read it
All right.
full screen.
I'll go ahead and see if you can read it. Go ahead.
I got 507.020 murder. 1. A person is guilty of murder with A. With intent to cause the death of another person, he causes the death of such person or of a third person, except that in any prosecution, a person shall not be guilty under this subsection if he acted under the influence of extreme emotional disturbance for which there was a reasonable explanation or excuse, the reasonableness of which is to be determined from the viewpoint of the person in the defendant's situation under the circumstances as the defendant believed them to be. However, nothing contained in this section shall constitute a defense to the prosecution for or preclude a conviction of manslaughter in the first degree or any other crime, or B, including but not limited to the operation of a motor vehicle, blah, blah, blah. I think that section A is the most, that's what we're talking about here.
Yeah. And so we're kind of talking about the excuse they give in that if he's acting under an extreme explainable circumstances excuse.
Yeah. Yeah.
And I think that's what
his position.
Go ahead.
I said, and it's from his position, what he thought in that moment.
Yeah, and I think that's what the defense attorneys are going after. I think they're trying to get to the lesser included homicide in this under this aggravated murder, because aggravated just means you used a weapon or something extreme. I don't know if DUI would be aggravated in that, but it says it's something.
Yeah, it does in that second section, including but not limited to the operation of a motor vehicle under circumstances manifesting extreme indifference to human life. He wantonly engaged in conduct which creates a grave risk of injury to another person, thereby causing death of another person. So,
Right.
yeah, if you're DUI and you're just going, think of Henry Ruggs, the NFL wide receiver, like when he was going like 120 in Vegas, in downtown Vegas, and hit that woman. I think that
Right.
would be where you get that.
Yeah. So I don't practice a lot in Kentucky, and I've certainly never practiced a capital in Kentucky. I have in West Virginia, and actually you have too, Wade, under your practice license with me this year.
Yeah.
That was a circumstance that we had someone on no bond and we was able to get them out.
Yeah, we were. In capital cases, it's different in West Virginia. No death penalty. A capital case in Kentucky is a capital case.
Right. And so I'm looking at the degrees of murder in Kentucky, and Kentucky only has the murder statute. I don't see any degrees here. Like we have first degree, second degree in West Virginia. And I'm not seeing that here. I'm seeing 507.2020 is murder, and then manslaughter in the first degree is that next one. And we'll download that, and I'll let you read.
Law.
Yeah,
more common law, not model penal code.
We'll pull that up for the viewers. Let's see here, slides. Your computer. Statute 2.
Well,
okay. Remove.
That kind of works out better for someone in his circumstance, I would say.
Can you read that?
Yeah. Manslaughter in the first degree. A person is guilty of manslaughter in the first degree when A, with intent to cause serious physical injury to another person, he or she causes the death of such persons or a third person. B, with the intent to cause the death of another person, he or she causes the death of such person or a third person under circumstances which do not constitute murder because he or she acts under the influence of extreme emotional disturbance. C, through circumstances not otherwise constituting the offense of murder, he or she intentionally abuses another person or knowingly permits another person of whom he or she has actual custody to be abused and therefore causes the death of the person 12 years of age or less, or is who physically helpless or mentally helpless, or D, knowingly sells fentanyl or a fentanyl derivative to another person and that kills them. So this one we're going to be here. And
yeah. So I think that's what they're going after. What's it? Class B felony. Let's see what the Class B felony runs in Kentucky. It's 10 to 20. So,
10. And then if the circumstances are crazy enough, you never know with the jury, like what's going to come out that was on that phone.
Exactly. And then we have, if we go back again and look at the statute 507, you actually have another that's manslaughter in the second degree. And so let's look at that. And this is a Class C felony, Wade. And so we'll look at this real quick. So let's remove that one. And then we will add this one. Oop. I guess it's better when you do it. All right. And then we will, it's uploading it. Hang on. Add that to the stage. Okay, what we got there, Wade?
We got manslaughter in the second degree. A person is guilty of manslaughter in the second degree when he or she wantonly causes the death of another person, including but not limited to situations where the death results from the person's A, operation of a motor vehicle, B, leaving a child under the age of 8 in a motor vehicle, C, unlawful distribution of a Schedule 1 or 2 controlled substance, and D, knowingly distribution of fentanyl or fentanyl derivative. So the don't think he can get it in the second degree. I think this is a manslaughter in the first degree is the best he can do.
So, I've pulled up the actual statute for classifications here. So a Class A felony is at least 20 years and more than 50 years. And then you got it. The next is a Class B, and that'd be at least 10, then but not more than 20 years. And then Class C, which is second degree manslaughter, would be at least 5, but not more than 10. So you don't think anything in that would fit what
No.
Stein's looking at here. So
No,
I
not
mean,
the situation. It's going to be either that murder or the manslaughter in the first.
so you think that at the very least, we're looking at life, but at the very least that we're looking at 10 years for Mickey Steins.
Yeah, I mean they're probably going to. Are there any other charges they're looking at bringing
that's all
against
one.
him? That's
That's
the
it.
they're going for that. They're going for the house.
Yep. And then that's what it's a little bit risky in a way, but I think that they got good evidence for it.
They do, but like I would throw gun charges, terrorism. I don't know. I'd throw them all on there.
Yeah, because you don't know, like I tell clients all the time, you don't ever know what's going to happen when you don't ever know what's going to happen when you get 12 people in a box. You may think that you are a prosecutor and you got the best facts in the world, and there's no way that a jury's ever going to find the defendant not guilty. And the same thing with the criminal defense attorney. You may think that you have the best facts in the world. Commonwealth can't prove this. They can't tie the evidence, can't tie your defendant to what they are saying beyond a reasonable doubt. And the jury brings back a guilty verdict. You never know.
Well, when you throw those lesser charges on there, you kind of give the jury an out. Like, oh, we don't have to find them guilty for this. We can go just find them guilty of that. So that the prosecutor's standing there 10 toes down saying, this is it. We're going to convict him of this. And they're going
so
for
it's all
it.
or nothing. So that's what it is. You either going to have to go all in or fold.
Yeah. And it's hard to fold on video. Like
it is, but I mean, we don't know what's going to come out. What Sheriff Stein seen on when he has to see the judge's phone, and then because he couldn't get hold of his daughter. Is that what it? He couldn't get hold of his daughter. Asked to use the judge's phone, see if he could get a hold of her on the judge's phone, and then something that he seen on that phone triggered him.
Yes, that's exactly what happened.
So I don't know if it's something that's going to be excusable. I don't know if it's something so just outlandish that you will have some sort of jury nullification.
I think there's a chance of that in this case. It's whatever's on that phone.
Because we've been hearing from multiple sources about the things that went on in Letcher County, and we're not saying that any of those are true. We don't know, but just hearing different people's TikToks and hearing different people's videos, they seem to allege that something nefarious was going on in Letcher County. I'm not like that's not our position. That's what we've been hearing.
Yeah, there's some crazy stuff coming out of it, and the people in the jury, if they're media literate at all, they've heard it too. They know the stories,
and especially this case is going to be tried in Letcher County. Is that correct?
Yeah, they got a special prosecutor,
and he's actually from the Attorney General's office. Yeah, the prosecutor's from the Attorney General's office, and the judge should be a special judge. Where is he from? Do you know?
I want to say Hillbilly Crime. She told us county.
Is it Breathitt County?
I don't know. I think it's a close by guy though. I mean, we listened to him. He sounds Eastern Kentucky to me.
Oh yeah, he's Eastern Kentucky definitely. Let's see here, if it tells in this article here. I don't know, but yeah, I would assume. Here we got this Jackie Seal special prosecutor. She says says to honor Julia H. Adams, but I don't think that's the actual judge. I think that judge recused. So yeah. Oh well. If anybody knows, put it in chat. Let us know. I'm sure Liz knows. But anyways, go ahead.
I was about to say September 2nd. We're gonna have some more stuff come out. So
Yep.
gonna have to do
Come
another
back on
episode.
September 2nd. Me and Wade will try to figure this out a little bit better than what we got going on right now. But Wade, I'm kind of liking this. I like this kind of view.
I think the
StreamYard.
view is perfect in StreamYard. We don't get the 4K of TikTok, but I think we sound good. I think the mics sound good, and
And we
the
definitely look
video-
good.
I think the video looks good.
Yeah. All right. You got anything else to add, Wade?
That's all I have.
All right, guys. Thank you for joining the Docket Dodgers. Like we said, we'll do another live on September the 2nd, but I'm fully confident that Wade and I will be back before then.
Absolutely.
All right, guys. See you later. Thanks.
Goodbye.